Hello, this is Matt on the Moon Family Sedan channel. Have you ever wondered what would it mean for XRP and what would it mean for Ripple's business in the United States if Ripple is victorious in the SEC v. Ripple case and immediately following that victory, the SEC appeals? What would that mean for Ripple's business in the United States again, and what would it mean for XRP holders? Well, I want to talk a bit about that, and I got a couple comments from this topic from attorney James K. Filan as well as attorney Jeremy Hogan. And I also want to share with you a separate legal topic having to do with LBRY. And I got a couple of comments from the official LBRY account on Twitter, as well as a couple of comments from attorney Deaton and attorney Morgan of the XRP community. And I'll just tell you this at the outset. The LBRY, they revealed one of the proposed terms of settlement from the SEC in that case. And it was that LBRY needs to stop tweeting. I kid you not. I kid you not. And then there's also this article that's on your screen from the Crypto Basic I want to touch on at the end of the video. This one's titled, Ripple and SEC Jointly Request Time Extension to Publicly File Daubert Motions. Oh no, another delay. Yes, technically, but this is not remotely bad, just to be honest. I'll share with you the specifics. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say are right. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. So there's an XRP community member who goes by the name XRP Deriv 76K JD. So of course the 76K in JD is representative of the 76,000 XRP holders that attorney John Deaton represents. And this XRP community member tagged me along with a number of others in the community and asked the following. If Ripple gets outright victory in lawsuit and SEC appeals to appellate court, what happens in interim? Does Ripple have green light to operate in the United States until final decision made? Perfectly reasonable questions. And even with me not having a legal background whatsoever, I do have some thoughts on, certainly on the second question. Let me address that. And then on the first question having to do with, what would it mean in the interim? I'll let attorney Filan and attorney Hogan share a couple comments on that. But on the second question of what does this mean for Ripple? Is there going to be the green light to operate in the United States when the final decision is made, assuming it is to the positive in favor of Ripple? Well, here's the thing. There's actually nothing, technically right now, there's nothing stopping Ripple from conducting business in the United States at all. In fact, the SEC, mind you, it's going on 2 years now. The SEC never even sought to stop Ripple from selling XRP that they hold for the last 2 damn years. So they haven't technically stopped anything. Ripple can do whatever they want in their pursuits to grow their business right now. So that wouldn't change, actually. But the thing is, and I'm sure most of you may be aware of this, the fact of the matter is Ripple has lost a ton of business in the United States. So a couple things. The on-demand liquidity corridors that Ripple set up that touch the United States are dead. For now, they're dead. Doesn't mean they won't come back. In fact, I'm optimistic that this is all going to work out in the end. On-demand liquidity will come back. Of course, if we get a bad ruling, then it's just dead here forever, at least with the utilization of XRP. But I'm optimistic that, we're going to get a ruling to the positive. So that is dead right now. But, in terms of the rest of the business, if you're just talking about RippleNet, which is just the messaging portion of these transactions, it is true that Ripple has lost a ton of United States customers and they haven't signed a single new customer in the United States. So what would this mean in terms of Ripple's growth if there's a positive ruling? Technically, nothing changes for Ripple. It's more a question of, what about all the partners that make RippleNet and on-demand liquidity possible? What about them? Because you can think about, like, for instance, on-demand liquidity partner, like Bitstamp, right? That was the major one. Bittrex is in the United States too, another on-demand liquidity partner in terms of the exchanges on the United States side. Well, it's up to them. So, like, if you have to have liquidity in order for this to happen, so it's got to come from one of these partners, an exchange partner. Is one of them going to, supply that liquidity? And again, it was mostly Bitstamp, almost entirely, from what my understanding is. Is that going to come back? Well, that I can't answer because that's an internal Bitstamp thing. But there's that, and then how many people are it's not even that. Actually, I shouldn't even go that direction. It's not so much about the interest in this side, because you're talking about market makers holding XRP. It's not like there's a lack of interest in the United States from people like you and me. That's here. It's just in terms of like whether or not we can buy and sell it. But if you're specifically talking about that on-demand liquidity, well, are they going to feel that it's safe to continue moving in that direction? And I'm not sure. I'm not completely confident, especially if the SEC ends up appealing here. But here's what Attorney Filan had to say on this topic. He said, the SEC will ask to stay the judgment pending its appeal to the Second Circuit. That means it will ask the court not to enforce the judgment until the appeal is over. That would be an epic battle between the parties, and whether the court agrees to that remains to be seen. So what Attorney Filan here is saying when he says, stay the judgment, the SEC would ask the judge to stay the judgment. That just means that, a stay just means temporarily stop a legal proceeding effectively. But Attorney Hogan seemed to be thinking a little bit differently, and he seemed to, based on the tone of his question, disagree to some degree. And he wrote the following. He said, if she rules simply that there was absolutely no Section 5 violation, what is there to stay, again meaning temporarily stop a legal proceeding, what is there to stay other than the typical post-judgment motions on costs, etc.? Which is certainly a perfectly fair question, and it depends on what Attorney Filan was thinking might get stayed. That's the question here, and I haven't seen him respond any further to this. But, if you're just talking about the outcome, if there is no Section 5 violation, then I get Attorney Hogan's point, there's nothing to stay there. But what if it's something else? What if it's something more consequential? What if it's an order? What if Judge Torres does rule on, what happens with XRP as it pertains to secondary markets? What does it mean if you and I, transact our XRP and we're both in the United States? Like, what are these transactions? What do they mean? What if we're buying and selling it from one another specifically? Well, if there's something to that effect, might it be the case, if there's something to the positive on that front, might it be the case that the SEC would seek to stay that particular judgment? Well, I wouldn't be surprised if that were the case. So it just depends. I don't know, because Attorney Filan didn't comment any further, but there's something that he was thinking might come from the judge that the SEC might not want to unfold, and it's probably not something having specifically to do with Section 5 violations specifically from Ripple, because again, if Ripple's found to be in the clear in this hypothetical, then what is there to stay? It's just there was no violation. So I don't know. I'm just kind of wondering. But if it is something to do specifically with XRP, no, that's a battle I do not think that the SEC is going to give up easily. I really do not. And even Attorney Hogan speaking recently, he was speaking on the Chain channel the other day with Attorney Deaton and others. And one of the things that he stated is that he was speaking recently to an attorney who's at the SEC, and it seemed pretty clear to him that their mission is and what they actually believe, even though they won't admit it, is that the asset itself is a security. And we all know how ridiculous that is. But that's effectively what they're going for. They just understand that they can't say that. And that's the idea that Attorney Hogan was sharing literally just the other day, literally yesterday. And it's outside the confines of law, so they're trying to find ways to word it in such a way that they think they may get what they want without outright saying, yeah, the asset itself is a security, because that's a losing battle for them. So they're not going to word it like that. And then there's this from the official LBRY account, as you all know to this point. A little over a month ago, LBRY did lose to the SEC, and now we're at this point where they're approaching settlement with the SEC, and that term, most of us when we hear settlement, we're thinking about before a judgment is rendered. In this case, the judgment's been rendered. We're just now at the point where remedies are being sought, fines and such, all that jazz. Well, whatever agreement is come to between LBRY and the SEC on the penalties, that's considered settlement still. So we're at this settlement phase, which is basically just the remedies portion of all of this. And my gosh, the SEC is going completely bananas. Would you expect anything less, though? These people are just terrible. So check this out. The official LBRY account wrote, literally no one at LBRY is receiving a paycheck right now. We're that broke. Meanwhile, the SEC is alleging we have millions in hidden money and is continuing to try to draw things out just to punish us extra legally. They're so effing disgusting. Yeah, and so I did read what the SEC wrote, and I covered it on the channel the other day, and select portions anyway. And the SEC is asserting that based on the funds that LBRY has, they could very well just sell those, and they're counting that in terms of something that's liquid. That means that basically the LBRY is just flush with cash. But LBRY can't sell that. They're not selling that. And so the assertions that they're making, it's completely ridiculous. And actually, to bring that point home further, let me share with you what Attorney Deaton had to say. So Attorney Deaton retweeted that from LBRY and said the following. The mission of the SEC is to protect investors. It's also an enforcement agency, so its job is to enforce the securities laws. Regardless of what I or anyone else believes, the SEC won. The mission of the SEC should not be to put LBRY out of business. It's a non-fraud case. The SEC was granted summary against Kick Interactive Inc.'s $100 million two-phase initial coin offering, or ICO for short. The SEC agreed to a $5 million fine. The SEC didn't seek disgorgement in that case. Ask why is the SEC doing this now? Because it's about crypto in general, not about LBRY. Exactly. So it does seem to me that in terms of the penalty phase of what's going on here, the SEC is being much more harsh compared to what we had seen in the past, as evidenced by what Attorney Deaton cited here. Even from a monetary perspective, there is no comparison. It's completely repulsive and disgusting. So this isn't about protecting investors. It's not about providing clarity for the space. It's about taking a hammer to everything. These people, and it comes down from the top. I really do believe, and fine, Jay Clayton kicked this all off, but Gary Gensler is like Jay Clayton on steroids. He's substantially worse. And he's the hammer, everything's a nail, right? And take a look at this also from LBRY. LBRY responded to Attorney Deaton and said, this is repulsive, but check this out. Literally the first thing they asked for in our settlement hearing was for us to stop tweeting. The first thing. They absolutely hate that we have exposed their sociopathy. And that's why they're out to punish us so badly. And that's the other thing. So yes, they're getting extra harsh here, just in crypto in general, especially under the leadership of Gensler. But if you've been following what the LBRY account has been saying publicly, and I love that they're saying what they're doing, kind of like, showing you what's behind the curtain here, the SEC obviously hates that because it shows the public just how awful that government agency is. Just absolutely disgusting and repulsive it is. And so, yeah, I do think that that's kind of resulting in perhaps a much harsher tone than they otherwise would, because LBRY fought back a lot harder than Kick Interactive ever did. That's pretty obvious, don't you think? I sure do. But to stop tweeting, don't say things on the internet about what's happening? Really? That's gross. Like, come on. Stop tweeting. Stop saying the bad things about us. Oh, you bunch of little baby back biatches over at the SEC, the ass hattery. My God. Attorney Bill Morgan of the XRP community retweeted that and wrote, "They are taxpayer-funded public servants. They wouldn't have any idea what it means to run a business while paying huge legal costs." Exactly, and they don't care about that. They just want to rip it all to shreds because they got their feels hurt because LBRY said some true things about the disgusting SEC government agency on YouTubes. That's what it is. That's what happened. And then there's this, and this actually isn't so bad. It's actually not bad at all. I just wonder, it's not gonna, in terms of this impacting the timeline for finality for the SEC v. Ripple case, I'm not convinced this is going to impact it whatsoever. But take a look. From the Crypto Basic, Ripple and SEC jointly request time extension to publicly file Daubert motions. And so you may recall Daubert motions have to do with complaints basically against expert witnesses. So if there's a complaint and there's against one of the expert witnesses, that's called a Daubert motion, and it could be because methodology used to come to a conclusion could be flawed, or there could be an argument that whoever the expert witness is just isn't qualified, and as a result that you get, chucked out anyway. So that's what they're talking about here. And the piece reads as follows. The Securities and Exchange Commission and Ripple have filed a joint request to extend the deadline to file their respective Dalbert motions and accompanying documents in the public docket. In a letter dated December 20th, 2022, the parties asked the court to extend the deadline to January 13th, 2023. It bears mentioning that prominent Ripple enthusiast and defense lawyer James K. Filan shared the letter. Quote, plaintiff and defendants jointly request that the court order that the parties must file the Dalbert motions and accompanying exhibits on the public docket with redactions consistent with the court's December 19th, 2022 sealing, ruling on January 13th, 2023, end quote. And so it's a delay, and as far as the rationale, I mean, they end up citing in this article, it's time of year stuff like this. They just both agree it's fine to have more time. But in terms of this pushing back some sort of decision for this case, I don't see it. There is more than enough information for Judge Torres to review in the interim. So the fact that this information would be addressed a little bit later will do nothing to slow down Judge Torres from reviewing the absolute torrent of information that is, the filings within the SEC v. Ripple lawsuit. There's no shortage of stuff for her to review here. So I don't think that this is going to matter whatsoever, but I just wanted to at least mention it. There was a small delay here. Whatever. It's a big nothing as far as I'm concerned. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.